In the spring of 2013, I listened as Angela Davis, lifelong feminist, anti-racist, and Marxist, activist, organizer, and scholar, articulated what she meant by abolition feminism. She argued that abolition feminism is a politics marrying struggles against interpersonal violence with struggles against state violence, including the racist, classist, and profoundly destructive criminalizing and punishing systems that the state putatively uses to address interpersonal violence. In addition to linking struggles against domestic and sexual violence to struggles against the prison industrial complex, abolition feminism links these struggles to those against all forms of state violence, including that meted out through military violence, settler colonial violence, climate destruction, and austerity. In addition, as others have placed mass racialized incarceration in the longue array of white supremacist control, Davis placed the movement to abolish state criminalization and punishment in the longue array of Black feminist abolitionist movements, following those against slavery and Jim Crow. While many of the people listening have been talking and writing about this pairing and also devising creative ways to do this work, this naming and this conception of continuity of struggle was profoundly generative. People at the conference took on Davis's call to develop our understanding and practice of abolition feminism, adding banishment systems to the manifestations of white supremacist state violence that we need to abolish, and movements that close asylums to the abolition movements that have come before. The talk and the Insight Collective and Critical Resistance Conference, of which it was a part, was a necessary solve for me. My niece, then 10, had recently attempted suicide and was, while I listened, locked in a psychiatric hospital. Her sense of her life as untenable came from the interactive and multiplicative impact of gendered violence and the criminalizing and punishment systems on her family. Abolition feminism, as practice, seemed like the only way to change the material conditions of Kara's life. My understanding of abolition as a way through family trauma was not new to me. In fact, the impact of intergenerational violence on my life is how I came to abolition. I first heard the word abolition used to describe the movement to end criminalization and punishment at Critical Resistance's 2001 Northeast Regional Conference in New York City. However, my friends and I had come to a resonant understanding during our years of homelessness and criminalization. I grew up in the 1980s and 1990s in a white working class family in a mostly white, mostly working class New Jersey town about 20 minutes from the George Washington Bridge. My family was not only stable, but generally happy and full of love. Then, when I was in 8th grade, someone raped my mom as she was leaving work late one night. My parents are both survivors of childhood sexual violence, and this experience shook them to their core. The next 6 years were full of accidental overdoses, psychotic breaks, homelessness, criminalization, suicide attempts, rage, and occasional violence, and lockups. In psychiatric wards, rehabs, halfway homes, group homes, and youth prisons for all but one member of my nuclear family, many members of my extended family, and most of my friends. As for me, I was periodically homeless from 15 to 19, sleeping in parks and in the homes of both strangers and friends. I overdosed at both 15 and 17, and I spent 5 months in rehab and halfway house at 16. Nonetheless, I was fortunate compared to most of my friends, who the court and family services had sent to multiple rehab, psychiatric units, youth prisons, and eventually county jail. Obviously, race and gender are key. There's no way that any Black or brown kid picked up by the cops as frequently as I was would have been sent to rehab and halfway house instead of a youth prison. Even in my case, however, none of the state's responses to the intergenerational violence flowing through my family fixed anything. These years left me with an incipient distrust of the criminalization and punishment systems. Then, when I was 24, I began to learn through teach-ins and other movement work about the prison boom, the 6-fold increase in incarceration rates that took place during the last quarter of the 20th century, and the role that mass racialized incarceration played in recreating and sustaining white supremacy. In the spring and summer of 2000, I worked with one of the many groups that helped to plan the protests that occurred during that year's Republican National Convention. Police arrested me and more than 500 others on the 4th day of the protests. As a result, I spent 4 days in a holding cell, 6 days in a medium security jail, and 2 days in a minimum security jail. While I was in jail, I spent most of my time talking to the women I met, nearly all of whom were Black, about their life histories. Each woman who I spoke to at the medium security jail was in for either an assault that took place in the context of domestic violence or for drug trafficking, generally in addition and to supplement a minimum wage job. At the minimum security jail, every woman I spoke to was there for either sex work or drug possession. I remember thinking, no one can believe that jails fix any of these problems that stem from poverty, racism, and cis-heteropatriarchy. What I didn't realize yet is that our criminalization and punishment systems don't only punish people who've experienced gendered violence, they make that violence more likely to occur, both to people inside these cages and to the partners of the people who the state has caged, as men who have been incarcerated are between 4 and 10 times more likely to be physically violent toward their girlfriends or wives than are otherwise similar men. Given what we know about rates of violence within prisons and jails, the lack of resources for mental health care for people who have been incarcerated, the impact of being incarcerated on people's relationships, and the impact of felony convictions on people's chances of finding housing or a job, it makes sense that jails and prisons fuel gendered violence. Taken together, my experiences taught me that criminalization and punishment systems control populations through segregation, confinement, and incapacitation, and myopically focus on individuals, obscuring both the social creation of harms and collective level responses needed to make harms less likely. Not only this, but they fail to keep us safe and are themselves a form of violence. Since criminalization and punishment isn't a good practice in need of repair, but rather an inherently harmful practice, I knew reforms, particularly those reforms that only bolster and secure the logics or practices of the systems, could never lead us to the world we deserve. Still, it wasn't until the last 15 years that the feminist anti-racist organizers leading abolitionist struggles in Chicago, Janae Bonzu, Jenica Jones, Mariam Kaba, Carlyle Pittman, Paige May, Erica Miners, Beth Ritchie, and so many others, taught me that abolition isn't only about getting rid of things that harm, like police, jails, prisons, detention centers, and militaries. It's also about creating and nurturing systems and practices that are supportive, like housing, jobs, healthcare, and community self-governance. Because while criminalization does not decrease the amount of harm that happens in our communities, the best available research finds that housing, employment, and healthcare do. Having decided to do whatever I could to help end criminalization and punishment and to help build a world centered in joy, care, love, and connection, I set out to do work that communities could use to fight criminalization and punishment. First, doing research on the role mandatory terms and sentencing enhancements had on increasing incarceration rates among Black people, and especially Black women. Since that time, I've been able to do some work towards the abolition of cash bail and pretrial incarceration. Keeping in mind that my work has always only been a tiny part of the work organizers and activists are doing throughout the country and the world, I'm going to take a moment to talk to you about the small role I've been able to play in this struggle. The United States cages 11 million people in city or county jails each year. 75% of these people have not been convicted of the crimes of which they are charged and are jailed simply due to their inability to pay cash bails. The Pretrial Justice Institute, of which I'm a member of the board, estimates the cost of pretrial incarceration to be $9 billion a year, which jurisdictions could otherwise spend on housing, employment, childcare, and community mental health centers. Beyond the monetary costs, however, pretrial incarceration, like all experiences of incarceration, takes people away from jobs, families, and schools, and is itself a form of violence. Likely through the weakened ties with families and communities, lost jobs and housing, deteriorated health, and disrupted lives that it creates, pretrial incarceration also increases recidivism, the odds that someone will be charged with a new crime while awaiting adjudication. Through these pathways, racial disparities in pretrial incarceration produce racial disparities in a plethora of lived outcomes, including housing security, family and community ties, and employment and educational outcomes. Adding to my very brief experience of pretrial processing, my bail was set at $10,000 in about 60 seconds during my pretrial hearing following my RNC arrest. I've spent 15 years researching pretrial decision-making and published 4 studies on the topic. 3 examined the State Court Processing Statistics Series, which follows the criminal processing of people charged with felonies in 75 major metropolitan United States counties in each even year from 1990 to 2006. The 4th examines whether and how pretrial diversions can help decriminalize and decarcerate Black and brown youth. Cumulatively, these studies find 3 things. First, racial disparities in pretrial decisions and outcomes include granting non-financial releases, setting money bail amounts, denying bail, and granting pretrial diversions are common and substantial among both youth and adults. Second, anti-Black disparities are largest during the decision to deny bail and among defendants charged with violent crimes, while anti-Latino disparities are largest during the decision to grant a non-financial release and among defendants charged with drug crimes, suggesting that criminal legal decision makers draw on racist stereotypes to supplement the incomplete information they have in order to make pretrial decisions. Third, the sizable racial disparities in pretrial decisions and outcomes are generative of racial disparities in later outcomes, including adjudication and sentencing, again in both the youth and adult spheres. As practitioners, policymakers, community organizers, and incarcerated people and their families increasingly have come to understand how cash bail punishes Black, brown, and other marginalized people, there has been a real movement to end money bail. Often, policymakers and large nonprofits present pretrial risk assessment tools, which aim to reduce recidivism, flight risk, and sometimes pretrial incarceration as the only alternative. Unfortunately, even when risk assessment tools are good at achieving their own goals, they do not sufficiently focus on release, and they maintain or increase racial disparities. We can do better. Adopting policies of universal release without requirements, with the option of detention with due process in limited cases, would be a genuine move towards the abolition of pretrial incarceration. Although a call for universal release often raises concerns about community safety, policymakers can look to the Juvenile Detention Alternatives Initiative's data, which show that in the nearly 200 jurisdictions where their policies are being implemented, substantial increases in pretrial release are associated with marked decreases in rearrests and failures to appear. Moreover, policymakers must recognize the violence of incarceration itself, as these institutions are sites of trauma and violence. They make people sick, and they sometimes kill people, especially during a pandemic. In response to the devastation that pretrial incarceration wreaks on people, families, and communities, the Chicago Community Bond Fund, the Illinois Coalition to End Money Bail, and other community organizations worked for many years to end both cash bail and pretrial incarceration, recently winning a huge victory with the passage of the Illinois Pretrial Fairness Act, which outlines a clear path towards decarceration, doing 5 key things. First, it completely eliminates cash bail. Second, it limits eligibility for pretrial incarceration to those who are charged with specific crimes and whom a judge finds pose a substantial risk of willful flight or harm to a specific person. Third, it limits the role of risk assessment tools in pretrial decision-making while increasing transparency about any tools that are used. Fourth, it authorizes police to issue tickets in lieu of arrest and also to release people whom they have arrested with court dates, skipping over a judicial pretrial hearing. Fifth, it reduces penalties for pretrial technical violations, like missing a court date or failing a drug test. This act has the potential to both dramatically decrease the number of people incarcerated pre-trial and to be a solid step toward attenuating the cumulative racial disparities in adjudication, sentencing, incarceration, and post-release supervision. However, many people who have watched the implementation and sometimes rollback of bills that limit money bail in other jurisdictions have noted worrying trends towards increasing pretrial requirements, including curfews, electronic monitoring, mandatory alcohol or drug tests, and mandatory mental health treatment, many of which set defendants up to fail, with jurisdictions incarcerating people pretrial when they do. Even when people do not fail these requirements, the requirements can cost people jobs, housing, and even custody of their children. in order to find out whether pretrial requirements, which jurisdictions sometimes frame as services, may actually be increasing the carceral net, I'm beginning a new partnership with the Community Justice Exchange to conduct research on the impact of pretrial requirements on individuals and communities. Our participatory action research will examine the impact of pretrial requirements on the number of people incarcerated pretrial and the number of people under the carceral net, partnering with community organizations in 5 jurisdictions to examine how these relationships have changed or stayed the same from 2015 to 2023. We hope that this research will be helpful to communities fighting for decarceration in these 5 jurisdictions and throughout the country. Meanwhile, I'll continue to bring my research and activism on racism, criminalization, and punishment into the classroom in my undergraduate and graduate courses on the criminalization and punishment systems, on police violence and community response, and on racism and resistance, where students enduringly ground my understanding of these systems in the realities of their daily lives and push me towards ever deeper understandings and actions.